Welcome to this presentation on transferring important medical decisions to loved ones, key legal options in the UK. When a patient can't make decisions due to incapacity, there are several legal routes that allow relatives or healthcare providers to act on their behalf. This guide will cover key methods to ensure the patient's wishes are respected and upheld in line with the law. First, let's talk about the advance decision, also known as a living will. This document allows the patient to specify their treatment preferences for situations when they are unable to communicate or make decisions. It becomes legally binding when the patient lacks the capacity to decide for themselves, ensuring that medical interventions follow their expressed wishes. Although it doesn't give decision-making authority to anyone else, the advance decision provides clear guidance to healthcare providers on the patient's preferences. The second legal option is the lasting power of attorney, or LPA. An LPA allows a patient to appoint a trusted relative or friend to make decisions on their behalf when they lose the ability to do so. The LPA can cover health and welfare matters, including life-sustaining treatments or financial matters, depending on the scope granted by the patient. It takes effect when a healthcare professional confirms that the patient has lost decision-making capacity. The LPA must be registered with the Office of the Public Guardian to be legally valid. Next is deputyship, which is a legal route that comes into play when no LPA has been established. If the patient lacks capacity and there are no prior legal arrangements, the Court of Protection can appoint a deputy to make decisions. It takes effect once the court determines the patient is unable to manage their own affairs. The deputy is typically a family member or someone close to the patient and is appointed following a formal court application. In cases where there are no legal documents in place, informal family decisions may be used. When urgent decisions are needed, healthcare providers often consult family members or next of kin for guidance. However, it is important to note that these decisions are not legally binding, and the final decision-making authority remains with the healthcare providers. Finally, let's explore best interest decisions under the Mental Capacity Act. This framework applies when the patient is unable to make decisions for themselves, and it requires healthcare providers to act in the patient's best interests. It becomes relevant when the patient has lost decision-making capacity and no advance directives or LPAs are in place. Under this process, healthcare providers must involve family members and consider the patient's known values, beliefs, and preferences. The healthcare team must carefully weigh all relevant factors, such as the patient's medical condition, their prior wishes, and input from loved ones. In making decisions, they must also explore less restrictive options that align with the patient's well-being. If there are disputes or uncertainty, healthcare providers may also seek guidance from an independent advocate or the Court of Protection to ensure the decision truly reflects the patient's best interests. This approach ensures that healthcare interventions, from treatments to end-of-life care, are based on what the patient would have wanted, even if they cannot voice it themselves. In summary, whether through advance decisions, lasting power of attorney, deputyship, or best interest decisions, the key aim is to respect the patient's wishes and ensure the best possible care when they cannot decide for themselves.
Thank you for choosing Turingmedschool. Good luck with your preparation.